Hey, everybody. Welcome to yet another terrific edition of Inside Family Law. My name is Jonathan Noble, and today's guest is the one and only Vancouver divorce and family law attorney, Ari Wormeli. You're going to love this episode. We do a deep dive and chop up some great issues in family law. Did you know that if you cohabitate with someone in British Columbia for 2 years or longer, or you live in a married-like state, you don't even have to cohabitate with them, but act as a married couple, you're considered married under British Columbia law. Yeah. We talk about prenups, we talk about cohabitation agreements, we talk about how to best protect yourself in his jurisdiction. Now remember, this is just two lawyers having a conversation. It's not what? It's not legal advice. We're not your lawyers. We're just giving you some information to think about. Be careful out there. Drop a comment if there's somebody you want me to talk to or an issue you want me to explore. Happy to have you. Thank you. Enjoy the show. Hey, everybody. This is Jonathan Noble with another edition of Inside Family Law. I'm delighted to welcome from British Columbia, Canada, an attorney who practices in the area of family law and divorce. And his name's Ari Wormeli. Ari, you got the floor.
Hi, thank you very much for the introduction. I'm a family law lawyer. I'm a partner at Y Law, a firm in Vancouver. I've been practicing family law for 11 years, I think now, since I finished my articles. Not quite, 10 and a half years since I finished my articles. I was called in May of 2011. Family law is what I do. We handle cohabitation agreements, people separating, people who've already had a trial and need to adjust child or spousal support, all those sorts of things. We do separation agreements, court orders, interim applications, appeals. If it's family law, we do it.
Great. Tell the audience a little bit about your background, education, if you like, some of the speaking engagements. I know you're highly decorated in this area.
Well, in terms of educational background, my undergrad degree is actually in theater studies from York University in Toronto. And then I got my Bachelor of Laws in Victoria. And then I articled for a year with McLean Law Group. And then stayed with them for, I want to say, 5 or 6 years, and then to Lindsay Kenny, and then here. I've done some appellate cases. I've written a couple of articles for a few publications. I did a speaking gig once for a professional training organization talking about how to properly fill out financial statements. I did a presentation for a notarial association out in the Lower Mainland near where I live, and things of that nature. I actually once testified as an expert in an American court. I think it was in one of the Carolinas, about how Canadian child support guidelines work.
Okay. All right. One of the narrow areas that we're going to talk about today is just a fascinating area of law. And I know a lot of the folks in my community also are interested in what's known as common law marriage. And common law marriage no longer exists in the jurisdiction where I practice in Pennsylvania. As of 1995, it's no longer recognized. I'm also licensed in New Jersey, and it hasn't been around in New Jersey since the 1920s. So, Ari, if you could just tell my audience or anyone watching this today, what is common law marriage in British Columbia, and why is it important?
Sure. Just to give you a little bit of background, common law marriage, the concept has been around for a long time. The CRA, our version of the IRS, uses it for tax filing, though they've got different criteria. And before 2013, whether you were in a common law relationship was important, because if you were in a common law relationship for 2 years or more, you could get spousal. Now, after March 2013, we have a new act called the Family Law Act, and you're entitled, if you've been in a common law relationship for 2 years or more, you're entitled to both property division and spousal support, potentially. It used to be that if you were in a common law relationship, you had to go through this vehicle called constructive trust to get anything, which was pain. And I think they decided to make things simpler. And the government did that, one, as I said, to make things simpler, and two, because a lot of people assumed that in a lengthy cohabitating relationship, they would have some rights when they split up. And a number of people were apparently very surprised to find out that they didn't. And I think that it's important because it can protect those kinds of social understandings, providing it's widely conveyed, hey, this is important, and these are the responsibilities of these kinds of relationships. It ensures that people will keep their promises, both spoken and unspoken. People still have the ability, and I think I may be talking about that later, to personalize things a little bit with the cohabitation agreement, but essentially it ensures that, for example, the classic case used to be the wife in a 20-year relationship who helped out on the farm for 20 years, had kids, and then at the end of it, in the 70s is told, well, you're not really entitled to anything. And I think many people would recognize that as being unfair, and that's what this legislation is designed to correct. I won't say that it always operates exactly in a way that I would consider fair, but that's the theory of it, and that's why I think it's important. It can be difficult to determine whether you are or you aren't in a common law relationship. There's no, unlike marriage, there's no ceremony.
Right.
Most of the time, there's no paper or anything like that. And so what you're left with is a list of criteria, and it's a long list of criteria. Not everything needs to be there. And that list includes things like, are you living together? You think, well, of course you need to be living together to be in a common law relationship. I mean, okay, but so you guys are in a long-term relationship and somebody goes away to France to study for a year. Does that mean it's over? Most people would say no. A lot of times when this issue rears its head, and I have clients who aren't sure about when their relationship started, or I'm a little bit worried about it because maybe we're close around that 2-year period, and I want to make sure, either depending upon who my client is, that we in fact are under, or that we in fact are over. A question that I ask is, well, when did you guys start spending more time with each other than not? Because people can maintain 2 separate residences. There's a case where one person lived in the US and one person lived in Canada, and they continued seeing each other for many years, and that was held to be a common law relationship, even though they maintained separate residences. There's a case where these people lived together for a while, but then stopped living together because the new partner wasn't really getting along with his common law wife's teenage stepdaughter. And so to preserve their relationship, they went into, separate residences. But, kind of like the traveling to France thing, it didn't take one iota away from their love or respect or the nature of their relationship,
Right.
That's how they did things, but it didn't change their understanding of their commitment to each other.
Right. I think it's a very slippery slope to here in, let's say in Pennsylvania, either you have a wedding or you don't. Either you exchange vows in a ceremony, get a marriage certificate or marriage license, or you don't. I'm very interested to find out how your clients navigate this slippery slope. And does the general population even know the law? Or could you inadvertently move in with your college girlfriend or boyfriend or whoever, and 2 years go by and you're married in the eyes of the law. Does that happen?
It could. And I suspect that most of the public doesn't really know the ins and outs of the law. I think that many of them would be surprised to find out that you could be in a common law relationship while nevertheless retaining two residences. The idea is that the court is trying to find out what the parties' objective intention or subjective, intentions towards each other, often using objective evidence as much as it can, photographs, Facebook posts, cards. Did somebody say, oh, yes, please put this person on my benefits? Did they tick off the box tax forms as common law?
Right.
Somebody got sick. Did, the other partner take time off work and go, spend time with them, take several weeks off work and spend time with them in the hospital? Did they go on vacations together? Do they have joint accounts? Because, the trick is, how do you distinguish from people who are in a common law relationship versus roommates who are having sex, right? And
exactly.
And get tricky. The law is gray. There's a long list of factors. It used to require a certain amount of dependence, but then they thought, well, that's kind of a real old school way of looking at things. And you don't need a spouse who's dependent on the other. It's more about, are you guys do you view yourselves as being in a partnership? And they try and look at things to determine that, what kinds of gifts are the parties exchanging? Is it, a box of chocolates and some flowers, or did somebody buy the other one a car?
Okay, so just through my lens as a divorce lawyer, as I'm thinking about people that will come to me for a consult. If I were in British Columbia, and let's say I was an orthopedic surgeon, and I'd never been married, no children, out of wedlock. And I meet a lovely young woman, and she's not a professional and she doesn't have the resources that I do. And I live in a big apartment in the sky somewhere, and I want her to move in. Am I taking a risk by having that happen if she stays for 24 months?
Yeah, you are, because I think the odds are, however you intend that relationship to be at the beginning, right? There's going to be Valentine's Day, there's going to be birthdays, there's going to be Christmas, there's going to be summer, you're going to want to go on vacation, you're going to take her with, and that it's very easy to creep your way into a relationship, even if that's not how you started out. And if you're not going to do that, you need to take a very deliberate approach.
So why don't you talk a little bit about how do you protect that client who comes into your office from finding themselves enmeshed and entangled in the Family Law Act of British Columbia, where, 2 months goes by and now he's got in a whole different set of circumstances in the eyes of the law. What do you do to help protect people?
Well, one thing that I would probably mention that I haven't really talked about yet is spousal support can be triggered in any relationship where you've been in a marriage-like relationship for any length of time and have children. So if they have kids, the 2-year mark may not be the be-all and end-all for spousal support. It still is for property, but not for spousal. So I would give that note of caution to the client.
So if you have a child with someone out of wedlock,
yes,
that even it triggers spousal support, even if you haven't been together for like a few months?
Well, and that's a good question. I mean, this act has been enforced since 2013. A question that I ask is, well, okay, how long do you have to be together to consider a relationship to be marriage-like? Clearly, it has to be some period less than 2 years. Otherwise, the legislation wouldn't be phrased that way.
Right.
Is a year sufficient is 6 months, something less than 6 months. I would be surprised if it could be something less than 6 months, but I think at 6 months, you're probably entering into some jeopardy.
Wow, what a gamble.
So, well, if you have kids, you're entering into some jeopardy, right?
So if you impregnate someone, she delivers a baby and then says, you know, I want to live near my family in Quebec, and she goes off, you could owe that woman child support because she has physical custody of the child in Quebec or some faraway place, and spousal support because you
potentially, and I would really advise not to do that, because if somebody, in order to relocate the children once they're born, if you're in BC, you need a court application or agreement, mostly. Before the children are born, you can move wherever you want. So if she moves to Quebec before the children are born and has the children there, and you're not able to move to Quebec, you could find yourself in some difficulty. You know, it's unlikely you're going to be able to be an equal parent, which means that you're not likely to pay reduced child support as a result. Visiting the kids is going to be expensive, and there's a whole host of things that come with that. But to move back to the common law issue, I guess what I would say is that they need to be careful. So no joint accounts, no joint property. I would tell them, don't go on vacations together. Don't introduce the person as your partner. You know, if they're your roommate, introduce them as your roommate.
Wow. Okay.
Don't take them to visit mom and dad, you know. Don't get them a ring. Don't give them a card that says, I'll be with you forever. You know, don't put them on your benefits. You know, if they're like, oh, geez, you know, hey, could you just put me on your benefits because I need some dental work, blah, 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 blah. Nah. You know, what else? Keep boundaries, you know, the degree to which you will be involved in each other's personal lives. You know, don't show up for, if they have kids, don't show up for school at the parent-teacher interview. You know, that's a bad signal.
Right.
Don't, just because it's easy, or you know, just because it's easy to say because it's what the other person wants to hear. You know, don't tell them, oh yeah, you know, I'm always going to be here for you, or I'll look out for you, or this, that, and the other, or, you know, don't make much in the way of future plans, you know.
You know, one thing that I read, many people think if they enter into an agreement confirming they are not in a common law marriage, the agreement will be affected and they do not have to worry about anything else. Obviously, that's not true, because could you talk a little bit about if somebody comes into your office and wants some level of protection, say a cohabitation agreement, what kind of things do you explain to them? Do you tell them, look, this is not ironclad, and somebody can always apply to the court to determine whether or not we were in a common law marriage?
Yes. And also, I mean, so I probably wouldn't call it a cohabitation agreement. The whole point of it was that they are not cohabiting. You know, I might reframe it, and there is a case where such an agreement was upheld. It was a short relationship, and I think that helped a lot. If people, you know, but I might be cognizant of the, you know, I would have a talk with the client about the reality of, okay, you know, do you actually think that you're not going to be in a common law relationship 2 years or a year and a half or a year from now, however long they've already been together? And because, yeah, you would, that agreement is worth something because it says, okay, these are what the parties are saying. But if there's a lot of evidence to the contrary, I think you might run into some trouble about whether or not, maybe whether things changed after that agreement. or whether, the validity of that agreement. Somebody's like, oh, no, it was a sham because he was worried about X, Y, Z. But, we bought this. Actually, maybe we didn't even buy this property together. The other person paid for all of it and put it in our joint names. And we went for vacations here, there, and everywhere. And we, ticked off common law on the tax form, and I'm on their benefits, and we had kids together, and we've got a joint account. I would have a lot of skepticism about whether that agreement would hold up, when you place it against the mountain of other evidence. I'm not saying it's worthless.
Right.
And if you've got like one or two of those factors, yeah, you might be okay. But if you get a bunch of them, I think you might be in trouble notwithstanding. So the question is, okay, so you're in a common law relationship. What do you do to mitigate it? And yeah, a cohabitation agreement, whether you're married or not, is an effective tool at reducing your obligations as they might otherwise be under the Act, or clarifying them. A lot of people don't like cohabitation agreements. They think they're, it's not romantic. Oh, we trust each other, et cetera, et cetera. I look at it as a way of having difficult conversations, because nobody likes talking about money. It's kind of gauche. It's awkward. But it is a way of structuring those conversations. And it is a way at looking about how each of you thinks about fairness and what each of you thinks is fair. Because what I will say is, if your ideas of fairness don't mesh, you're going to have other problems, right? If you guys can't get it together enough to make a cohab, you're probably going to break up anyway.
Right. Well, here's the thing. Let's say somebody's been married and divorced. They went through a bad divorce and they lost, half their assets, and they're gun shy now. They don't want to enter back into holy matrimony. I don't blame them for not wanting to at least protect themselves to the greatest extent possible. I personally think that vetting someone, especially for covert narcissist personality traits, could take more than 2 years. You want at least a year and a half, 2 years, or 3 years. What's the rush? Especially if you don't want to have children. Say you're in your 40s and you're successful, or older, 50s or 60s, or even older. It just seems like a minefield. It's like a default position in your jurisdiction. You're going to be married under the eyes of the law if you check not all of these boxes, just enough for the judge, in this case, will make a determination to say, yep, I think, and they have wide discretion. The courts have wide discretion, and it's hard to overturn, because nobody can really question how they weigh credibility and the weight of the evidence. And a lot of it comes down to the evidence and the credibility. So again, I'm going to go back to the question, how would somebody, and I know I have viewers in my audience in Canada that raise this issue all the time. What do we do? And you're the guy to, by the way, if you're watching this, this is not legal advice. I'm not your lawyer. Ari's not your lawyer. We're just two lawyers having a conversation. But could you speak to that?
There are limits on your ability to protect yourself.
Okay.
Especially, if you are common law, or you put yourself at risk for being common law, there are limits to your ability to protect yourself. A cohabitation agreement, especially in shorter relationships like less than 10 years, is pretty effective. It has to be something that the court can still overturn it, but they have to view it as not just unfair, but significantly unfair in order to do that.
Right.
And, common things that I might put in there might be, minefields. Like, we have these things called excluded assets, gifts or inheritances that people receive during the relationship, or things that they bring in to the relationship. Those are presumptively excluded. The increase in value is presumptively shared. But if you dump it into a jointly held asset like a house, you may well lose the exclusion. So a common thing to see in a cohabitation agreement is just because I take this excluded asset and put it into something joint doesn't mean that I lose an exclusion.
But the burden of proof would be on the person who had the money to begin with to back it out and show where it went.
Yes. Yes.
I always prefer to tell my clients, to the greatest extent possible, whether it's a prenup or cohab agreement, keep it separate. Don't title it in two names. Don't commingle it, because the burden's going to be on you to back all that out. So
yeah. Well, I mean, and one thing that I do in cohabitation agreements is I attach a lot of the financial disclosure to it. So, because 15 years on, good luck getting a bank statement, right? So I have statements of people's assets and debts as they were at the date of cohabitation, tax returns and that kind of thing. It's a lot of attachments, but I think it's a good thing to do. It also reduces arguments about what was or was not disclosed. If somebody comes back later and was like, oh, they never told me about this asset, well, it'll be attached and there will be no doubt as to what was disclosed.
Right.
But
what about somebody who has a strategy of they're living together, or even if they're not living together, because that is not a slam dunk acid test for common law marriage. You could still,
right.
We know about that case in Ontario.
Yeah.
Pardon?
It's important, but it's a factor.
Right. Just one factor.
Yeah.
But, they'll live together for a year, 11 months and 3 weeks, and then they'll break up, and then they'll reconcile maybe 3 months later. Does the clock start ticking all fresh all again after that?
Yes, it does, because the way the law is written says they have to be living for 2 years continuously.
Right.
Once you hit that 2 years, if you break up and then resume cohabiting within, I think it's 90 days. It might be 60, but I'm pretty sure it's 90 days. Then everything carries on. If you're separated for longer than that period, then depending upon how much longer you remain together for, there might be arguments about whether or not that first portion of the relationship is spent, essentially. Because you do have, after you guys split up, you got 2 years to apply for relief. If you don't do it within that 2 years, you're statute barred. Well, except for child support and parenting.
Right.
But spousal and property, which would include pension division, you've got a 2-year ticking clock from the date of separation.
So just so I'm clear, you're living in a marriage-like state for 2 years.
Yeah.
Let's say 2 years and 1 day.
Yeah.
That person would be entitled to some portion of your pension benefit, just based on the fact that you're living in a marriage-like state.
If it was accrued during the relationship, or the extent to which it increased in value during the relationship, yes.
What about if you own rental properties and the increase in value of that real estate during the time that's also part of the quote marital estate?
That's why a cohab agreement is important, because at 2 years and 1 day, if they had a cohab agreement saying you don't get anything, I think that would be very likely to be upheld in that circumstance.
Is it possible? Anything's possible, but could that be construed as significantly unfair?
I don't think on a relationship of that length, no.
Okay.
One of the difficult parts is that because this act is, I'm going to say new, 2013 is a long time ago, but nobody's made, there aren't any cases where somebody's made an agreement under the new act and it's a 20-year relationship and the court is deciding what to do with it. And that's sort of where it gets murkier. So for example, what I do is what I typically do, and of course it depends on my client's instructions, but usually what I recommend is a period of 0, where the other person maybe gets nothing, and then a period of small incremental increases in entitlement leading up to somewhere, depending upon how much risk my client wants to take, between 30 or 40% at 20 years and staying there.
Right.
Now,
go ahead.
Is because I don't think 40% of whatever they would be, as opposed to the notional 50% that they might be entitled to under the Act, I don't think that that's unfair enough to be significantly unfair, even on a 20-year relationship. Anything below 30 on a 20-year relationship, I think you're playing with fire. And anywhere between there depends on how much you like to gamble.
Right.
Because I just don't know, and nobody else does either right now.
Right. I read some of the case law in your jurisdiction, and I looked at the statute, and it is really murky because there's not a lot of case law on it. And the terms such as significantly unfair or unreasonably fair or unfair, it's just, wow. I would hate to be the case of first impression and lose. Which leads me to my next question. In some of the cases I read, it seems like the courts in British Columbia have what's known as a summary trial to determine whether or not you are, in fact, considered to be in a common law marriage. So is a summary trial like a shortened trial where evidence is limited? Could you tell the audience a little bit about that?
Well, sometimes. Summary trial is a mechanism that can be applied to anything. The issue is whether or not credibility is at issue. So there are many times when I might say that actually summary trial might not be appropriate for determining whether or not you are or are not in a marriage-like relationship. It depends on what degree it depends on objective documentary evidence or not. It may be something that's discernible, because I don't want to get too much into the test for having a summary trial or not, but the question is, even though there may be divergence in the evidence, whether a judge is nevertheless able to discern the essential facts based on all of the evidence, because summary trials are affidavit evidence only.
Okay.
Have discoveries, and you can throw those transcripts in, but it's affidavit evidence only, so it's written evidence, and where that conflicts, a judge may not be able to sort it out unless there's a mountain of documentary evidence on one side or the other.
So there's no testimony taken in a summary trial?
No oral testimony.
Wow. So the parties themselves can't testify. It's just whatever documents are available to tip the scales one way or another.
Yes.
Wow. Okay.
And that's done, that's an efficient way of resolving things, because oral evidence takes forever,
Right.
And when it takes forever to do that, your costs go up, and there are delays. Right now, if you want a 10-day trial, you're probably waiting a year. Whereas if you want a 1-day summary trial, you could probably do that in 3 months.
Okay. So you can get a summary trial just on the narrow issue as to whether or not we were in a common law marriage.
And so, what you might consider, because that's kind of a threshold issue that has a huge effect on everything else, and bluntly, a ruling one way or the other may produce a ready settlement. Now, there is law that says, hey, we don't want to use summary trial to litigate in slices. But, where you get a big issue like that, and where the parties tell the judge, look, this is going to make a big difference in how we approach the case, and why should the parties prepare for a 10-day trial when, if there is no marriage, we don't need a trial.
Exactly.
Or if we do have a trial, maybe it might just be a constructive trust claim or some other thing, something very shortened, we are going to need a trial. And we won't be dealing with the uncertainty of whether or not these people are in a marriage-like relationship, and if so, for how long.
Right. Okay.
And that will be cleared. And that, the motivation there is that knowing whether they were or not and how long may help the parties to settle if they've got certainty over what that's going to be at trial.
So would they file a divorce complaint initially and then have a summary trial if they're in a common law marriage?
Yeah, you file, it wouldn't be divorce because divorce is only for married people, but somebody would file something called a notice of family claim. At least the person who wants to say that there is a relationship would file the notice of family claim.
Okay.
The person who doesn't wouldn't, because you're kind of shooting yourself in the foot there, because you have to say that there's a claim under the Family Law Acts to do that.
And there's 2-year statute of limitations from the time you separate to file that. After that,
yeah, so you'd be waiting out the clock if you thought there was no marriage-like relationship.
Right. If the parties have equal earnings or earning capacity and kind of equal assets, is it a waste if there's no children involved for somebody to file that claim?
Probably, yeah.
Okay.
You never know what the other person has. That's what discovery is for. But yeah, if you truly had equal incomes and equal amount, when I say equal property, I want to say equal amounts of property subject to the act. It's possible, for example, if both of you came in with assets and one went up by a lot more than the other, even though maybe now they're equal, your share of the pot may be more, right? So let's say you start out with a property that's worth $3 million, and right now it's worth $3.5 million. So the increase in value is $500K. The other person gets $250, presumptively. The other person started out with a property that was worth $2 million, but is now worth $3.5 million. So yeah, same assets, but your 50% of that is $750. Set it off against the $250 you owe the other side. You can still get $500K out of that potentially. So
right. Just another question about the Family Law Act and what's divisible. Family debt under the Act looks like it's divisible too. So hypothetically, if you move in with someone and that person is a shopaholic, say a closet shopaholic, runs up $100,000 in credit card debt during that period, could hypothetically you be on the hook for a large portion of that?
Yes, yeah, you could be on the hook for 50% of it easily. The issue, you can reapportion. There's something called Section 95, which allows for the court to move up or down from the presumptive 50-50. And you might be able to make some arguments about reapportionment. Certainly if it was done maliciously, things are kind of rocky, and in the 30 days before separation, the person racks up a huge bill. There might be some questions about whether or not that was done in good faith. Right. And there might be other factors as well that might lead to the court moving up or down on that. But presumptively, if it's debt that exists as at the date the relationship ended and it did not exist, the other person didn't bring it into the relationship, yeah, the presumption is 50-50.
Wow.
And but again, reapportionment is common in short-term relationships. So if that's in a 2-year relationship and somebody racks up $100K and the other person doesn't know about it, that's the kind of thing that might end up getting significantly reapportioned to the other side just based on the duration of the relationship, because that's a factor in reapportionment, is how long the relationship is. And anything under 5 years tends to get some measure of reapportionment, basically. So there is that. It's a danger. And I always, I do tell clients, and this is one of the other discussions I have when talking about cohabs, is if you've got a saver and a spender in a relationship, well, the spender's had a pretty good time. They've had a comfortable lifestyle, they haven't really had any deprivation, and the saver has, been saving everything up for their retirement. But guess what's left to be split at the end of the relationship? The saver's savings. And a lot of people, understandably, are not happy when they confront that situation. And that is something that a cohab can help alleviate to some extent.
Okay. Wow. It's a minefield.
Yeah.
Just one other thing regarding debts and common law marriage, based on what I've read, you really need to vet carefully before marriage. I tell any potential client that I have, whether they come in for a prenup consult or anything else regarding what they could expect if the marriage becomes non-functioning. And there's a large percentage of people who marry someone and they don't know what their credit score is or what they've got in debt. It's a mess. I want to move.
I was just going to say that's the reason why I can encourage the cohabitation agreement, because it's a structured way of looking at all these things. I mean, the other person having a great income is all right, but actually, if somebody's got an income of 300K and they have actual credit card debt, that would be way more concerning to me than, if somebody in a higher income bracket was marrying somebody who was 60K or earning 60K, but living within their means.
Right. I agree.
Much, and you've got credit card debt, there's a problem.
Right. I agree. It's really a red flag. I want to move on to prenuptial agreements, one of my favorite topics. And it seems to me, based on what I've read and what I know about the Family Law Act, prenuptial agreements, that in British Columbia, maybe more than other provinces in Canada, the courts have latitude to modify or set them aside. And
yes,
that's very concerning, only because that's the antithesis of how prenups are viewed in a state like Pennsylvania, where they really go by contract law. Could you talk a minute about how you can best protect your clients in British Columbia from having the court either modify or set aside completely a prenup? And again, everybody, it's not legal advice, two lawyers having a conversation. Ari, you have the floor.
So that really gets back to, and I was talking earlier about significant unfairness. So your goal is to make an agreement that's a departure from the act, but is not so much a departure from the act and so radical a departure that the court's just going to go, oh, that's significantly unfair. That's one thing. The other is to ensure that your client's done full disclosure. Because if full disclosure hasn't been done and the other person didn't know what they were giving up, well, then congratulations, you have a very expensive paperweight.
Right, exactly. I try to tell that to my clients all the time. I've had clients that have millions of dollars and they don't want to tell the prospective bride in this case, but I'm like, then don't get married and don't get a prenup, because you have to tell them everything, all debts, all liabilities. We append them right to the documents.
If you don't trust the person enough to make that disclosure, you should probably think about why you're marrying them. What is it about the relationship that you want to preserve?
Right. Okay. Can you waive alimony or spousal support in?
Yes.
Okay.
You can, but like anything else, the question is, well, when you separate, is that still reasonable? For example, if you don't contemplate having children and your income increased significantly, or maybe the other person wound up being a stay-at-home parent, and the relationship, it's a 20-year relationship, that waiver is not going to be terribly effective. It's a matter of, one of the things is looking at is, to what extent has everybody's situation at separation, to what extent has that situation departed from what people indicated their expectations were in the cohab? You can do that through recitals and say, look, I'm going to keep working, or, I'm going to take some time off. And that also goes back to fairness. When I'm representing sometimes lower earning clients, and the other person wants to say, oh, I'm not going to owe them spousal, and it doesn't matter what labor they put in and whether they stay home and raise the children. I may say to that person, look, this person doesn't value your child rearing or domestic labor. So think about whether that's labor that you want to do with this person, because they think that, if you take, if you've got 2 kids and you take a bunch of time off work and that disrupts your career track, that's worth nothing to them. And that's what this person is saying is fair. Now, if you think that's fair too, then great, you guys are simpatico. If you don't, you have a difference. And, you also need to know this person doesn't really respect that kind of labor. So when they get home from work and you've been dealing with the kids all day, are they going to appreciate that? Signs say no. And that's, and that's even where, when I'm on the other side, I do encourage people to have something of a realistic view about that. You love this person. Is this fair? And while it's always good to sort of not be forced into something and have options, that's the great thing with the cohab is you can structure it. It doesn't need to be full on, you pay what's according to the spousal support advisory guidelines. You can work out something different. It may have a better chance of being upheld because it may not be significantly unfair, and it may not depart significantly from what the parties contemplated when they entered into the agreement.
Is there any time where you would advise somebody to have both a cohabitation agreement and a prenuptial agreement in case their situation, their marriage-like state exceeds 2 years, where they're covered both ways?
Well, so in my view, if you're signing that kind of agreement, you're basically bringing yourself under the auspices of the act. So I probably wouldn't be doing that for somebody who doesn't intend to be hitting the 2-year mark. If they think that they will be in future, I would say, look, they're not now in a common law relationship, but they have been living in a marriage-like relationship since X. And if they continue to do so, and then they will be. And I might also say that they're contemplating getting married. So that's a great thing to have in there, because if they don't get married, well, fine. And if they do get married, well, it's not a change from what the parties were thinking when they were doing their cohab. Or prenup basically amounts to the same thing. They're just different in BC at any rate. They're just different words for describing the same thing. You call it a prenuptial agreement, a cohabitation agreement, or a marriage agreement. Obviously, you wouldn't have a marriage agreement unless you were married, but they serve the same function.
Yeah. I like to recommend, in the strongest possible terms, to my prenup clients, get it done before the wedding invitations are ordered.
Yes.
I've never had a prenup come back with no changes, and some of them have taken months to negotiate. What's your view on that in terms of timing?
I would say a couple of things about that. One is timing is a little bit important. Agreements can be set aside for duress, undue influence, or unconscionability. Normally, you don't reach those heights. But for example, you give this, the invites have gone out, the wedding's tomorrow, and you surprise somebody with a prenup and they sign it, you may be in trouble.
Right.
At that point, if it's that close, there's just understandably, there's a lot of pressure on the person to sign it because the wedding is tomorrow. Everybody's there. The wedding's been paid for. People have traveled. You're playing with fire there.
Right, I agree.
But what I do tell people is, look, reapportion. Yeah, it is best to have it before the wedding. If it gets signed the week after the wedding, it's not a big deal, because if you guys split up, like let's assume you guys haven't been cohabiting, right? So there's no major markers or milestones that are going to pass in that 1 week. The only major thing is you're married, and yes, that person has entitlement. On a 1 week relationship, I'm not real worried about, about complete reapportionment in one person's favor or the other.
Sure.
and, because duration of the relationship is a factor, I'm not too worried about it. So now, having said that, that does mean that you actually need to do that, and you need to make sure that it just doesn't get lost on the never, never plan, because then you could find yourself in some difficulties. And so I would caution that, you need to have a drop dead date. And I would say if you're more than 2 months out from your marriage, you need to be thinking real hard about dropping dead, because it's not going to age like fine wine.
Right.
But having said that, it's not the end of the world if you sign it a week after the marriage. Nothing big is going to come of that.
Right. I want to ask you a question that crossed my mind, a hypothetical. A guy moves out of his marital home in British Columbia, and he cohabitates with another woman for 3 years. He doesn't get divorced from the first one. He just left the marital home. Now he's living with his girlfriend of 3 years in a married-like state. There's no question about it. They're living in a married-like state.
Yeah.
If he dies, first of all, who's his wife? And two, if he doesn't die, is he now faced with two possible family court actions against him? The original wife, who he married in a ceremony, and then the one he lived in a married-like state for more than 2 years.
Actually, there is a Court of Appeal case on just that issue. In this case, he was married to one individual and had children with her, and he had a very long-term, I want to say it was somewhere in the vicinity of 20-year relationship with somebody else that was common law. They were not residing together for most of that because the common law partner had some mental health issues and became a hoarder, and they had some difficulties in that area. But the Court of Appeal did indeed find that there was a common law relationship there, and I think the result was that there were essentially two estate claims in that action. If you're the family law one is, going to be, if there's a clear separation, the tricky part is, well, okay, so I'm going to say wife one in this instance, we have to deal with her claim first, because his claim, the other person's claim, and I guess it could be a woman too, depending upon everybody's orientations. But the central person's partner, I'm going to say, the central person's share in those assets and what the common law partner can share in can only be determined after you've carved out spouse number one's portion, assuming that they've separated.
Got it.
And so you'd have to do that. And yes, they would have two claims. And yeah, it would be a pain in the butt. And I don't envy that person's legal bills.
No, I agree. A lot of this stuff can be avoided with using a little bit of common sense, which is one of the issues that I like to talk about with my audience and my guests, guys, girls, whoever. Know what your rights and responsibilities are before you make any sort of commitment or cohabitate, and know how you can best protect yourself, because you don't want to end up in court with a lengthy, protracted legal battle. It's just not the place to spend your resources. I know that sounds counterintuitive coming from a divorce lawyer, but that's a good segue into the next thing I want to talk about. And that's when you find yourself in need of a divorce lawyer, the aggressive lawyer versus the assertive lawyer. And Ari's on his website, and I'll put a link to this below in the show notes. He had a great posting by his law partner about the differences. So if you could speak to that a little bit, and maybe give people guidance, because a lot of people think I'm going to get the most rabid dog I can find to represent me. And it is really sometimes not in their best interest to do that. So I'll give you the floor, Ari, talk briefly about that.
Yeah. I mean, so it's natural to say, oh, I want a bulldog, I want this, that, and the other. I mean, for starters, you pay your lawyer on an hourly rate. It's not, how far along the file has been moved along, what kind of position you're in. You pay them for the work that they do, regardless of whether that work is particularly productive. And so if you engage somebody because you want them in court all the time, you want them to bump out the other person's claim, even though, yeah, so it's bumped out and then the other person could just bring it back on. You want them to bring on all kinds of disclosure applications, even though the disclosure is of marginal relevance. You want them to do interim applications for things that aren't really urgent. You want them to go to court on the off chance that you can actually get heard on a given day rather than waiting for a full day hearing, because that's probably what it's going to take. All those things are things that aggressive lawyers can do. And they might do, because they keep pushing on the other side, right? They're being aggressive. But a lot of those things are also descriptions of what I would call wasted money. And they can be very expensive. I
think that's a good point. I mean, your lawyer's going to give you the strategy and hopefully you guys mesh. I know with my clients, I won't take a case if I usually will not be somebody's second and definitely not their third lawyer. And if their first lawyer has an outstanding reputation and I may have had cases against them in the past and I know they do great work, that's a red flag. But the lawyer will set the strategy, and clients, at least in the US, have the ultimate decision whether or not to settle. Yeah. So if that's the case in British Columbia, if you don't follow your lawyer's strategy, you're going to hamstring yourself. You got to listen to the person that you hired, or why hire them? So I see people on the other side of my cases sometimes where they won't settle. They'll demand a trial. The trial will cost them thousands and thousands of dollars, and they end up getting less than what they were offered to begin with. So don't let that be you if you're watching this.
There's a case called Negus and Yahia where somebody tried to sue his former lawyers, essentially, because, well, I say sue, but the basic thing was he didn't want to pay their bill. And he wanted aggressive lawyers, including he'd apparently hired a civil lawyer who was sort of spoon feeding the family law lawyers things and telling them, oh, do this and do that. And they were things that bluntly just didn't make sense to do. And one of them that I remember was they wanted to apply to strike a notice of family, the family lawyers to apply to strike a notice of family claim. I mean, okay. And yeah, maybe the pleadings are deficient. But as long as you understand what they are, all that's going to happen is you're going to go to court and the court's going to go like, oh yeah, no, that's deficient. It's gone. And, because they're married, there's no limitation period because those clocks only start running once you're divorced. So it's, they'll just refile as long as they're within the limitation period. So where does that really get the client? Nowhere.
Exactly.
It's a complete waste.
Exactly.
And courts aren't fond of those kinds of complete wastes anyway when it comes before them. So you have to be careful about that. And that kind of litigation makes things difficult. Family law is a difficult place to be in, and it's difficult for everybody. It's a hugely stressful process. It is very easy to get people ramped up and amped up to a point where they're not thinking straight, and they just, they want to win. And winning is kind of an anomalous thing in family law. I remember attending a settlement conference once, and I spoke to the judge and I said, words to the effect of, well, we're here because it was a settlement conference, from some assistance from your lordship to put these parties in a position where they're each going to be equally unhappy. because that is a good hallmark of a decent family law settlement where everybody is equally unhappy.
Right.
I've had occasions where, I've gone to court and I've won, but the client hasn't been happy for whatever reason. Maybe it costs too much money to do. Maybe I've just, because especially if you have kids, you're going to be stuck in a co-parenting relationship with that person for, at least until the kids reach adulthood. And you're going to have to get along. And sometimes it's just not worth it.
Right. Yeah. What is the emancipation age, out of curiosity, in British Columbia?
The age at which a minor becomes a legal adult is 19, but for the purposes of child support and so on, it's possible that a child may still constitute, if you're married, what's called a child of the marriage after the age of 19. If for some reason they're unable to withdraw from their parents' charge, the most common reason is because they're in full-time attendance at a post-secondary institution. They may also be disabled. If they have a disability or some challenges which are going to prevent them from ever being economically self-sufficient, they may constitute children for a long time and maybe forever, conceivably, depending upon the extent of those challenges.
So in British Columbia, your child graduates high school and goes on to secondary university until he's 23. You could, let's say they go to University of Saskatchewan for college. You could still be paying child support for a child who no longer lives with the other parent?
Well, okay. Now, when a child hits the age of majority, it is not atypical, especially where they're not living at home, it is not atypical for support to be paid directly to the child. So I should clarify that. But yes, it is entirely possible that you will be paying some measure of what I would call basic support, plus, tuition, books, and so on and so forth on a proportional basis with the other parent. And if the child, even though the child may be residing primarily at university, if the child is going back, to one person's house or the other, say during the summer break, you might still be paying the other parent some measure of money because they still need a house with X number of rooms in it.
Right.
And that kind of makes some sense to me. Now, it will be expected in most cases that the child will be making some contribution to their own education, and so you might look at, well, what can the kid earn in a part-time job? And not all of that, because family law is the grayest of legal areas that I could think of, but, a percentage of that, not all of it, but it's not uncommon for the court to say, okay, well, all right, let's just say 50% of that's going to go towards their education because the child should keep some fruit of their own labor. You want to encourage that kind of mentality. And then, the rest might get split between the parents proportionally. And then there may be questions about the degree to which the child might have to take out loans, depending upon the financial circumstances of the parents.
Right. So just a quick message to my audience. I know I have a younger demographic that watches sometimes. Be careful. Be careful out there regarding getting people pregnant. And you might be responsible for, if I'm hearing this right, if you're in British Columbia, through post-secondary to educate this person, and certainly at least until they're 19, that could change the trajectory of your life financially. So be careful out there. I've seen so many guys hamstrung by that in child support court, and they get taken back, and it's a mess. So,
it can be significant.
Yeah, it's and the stress that it involves is even it could really hamstring you. Anyway,
especially a one-night stand.
Yeah, these one-night stands turn into 19, sometimes 23 years.
And then you repartner, that person wants to have children. And now you're still having to pay a lot of money for child number one and trying to figure out what's left over for child 2 and 3. There are issues about first families first and things like, yeah, it can get messy.
Right. Word of caution. These are real life situations. You could go to any child support office in any jurisdiction pretty much and see the downtrodden spirit that a lot of people leave there with, because they lose a large portion of their income. I don't know about in British Columbia, but in the US, child support's not tax deductible. It's like, and the person getting it isn't taxed on it either. So sometimes based on your income, it could be a huge windfall. If you're a professional athlete watching this, or somebody who makes that kind of money, sometimes they pay $100,000 a month or more, depending upon how many children and what their earnings are, especially, highly, highly paid players. So if you're a highly paid businessman, same thing. Usually there's no cap to it either in most jurisdictions.
In Canada, actually, there is. Technically, there's a what's called the 150K cap. But I will say that there's a lot of authority for suggesting that even in amounts up to 1 million, that cap may not be applied. It's up there, and it's out there, and there are some circumstances that may justify its application at amounts lower than 1 million. But you're sitting around 300K or something like that. It would be very rare for that to be applied.
Right. Right. We're coming close to the end of our segment. It's been a delight having you. Is there anything that you want to add? And I want to also ask you to tell people where to find you.
I think we've sort of talked at least about those areas. I guess I do want to say that cohabs can be an important tool for parties to assess how each other thinks of fairness and what their expectations are regarding their contributions and their obligations towards each other. And I think it is a way of structuring important conversations around finances, and making sure that there has been disclosure and that everybody knows what the other person has. And that's important. Most people who wind up in my office, you think, oh, cheating or, this, that, or the other. It's actually not the most common thing. Most of it are arguments, or sometimes there is cheating, but a lot of it stems from financial issues and financial mismatching. One person feels like they're not being valued, because the other person, isn't sharing everything that they have, or, somebody else feels like they're just a checkbook. And that can lead to a lot of other things. You add children into there, which can add stress to a relationship, and boom, somebody's sitting in my office.
Right. Exactly. Same. Ari, tell people where they can find you, and the best way to get in touch with you if they're in the British Columbia area and they want a consult or they need a great divorce lawyer.
So our website is www.ylaw, that's YLAW.ca. And you can pop on there. There's a blog. You can read about a variety of interesting topics, or maybe they're not interesting, but they're things you need to know.
There's some good articles. I read them.
Yeah.
Many of them. And
you can look at everybody's biographies. It's got our contact information on there. Our phone number is 604-974-9529, and you can call and get a consult, though we are fairly busy. I'm actually not sure how many people are taking consults right now, but you can absolutely phone and we'll run a conflict check and find out for you. I will say an ounce of prevention is worth a pound of cure. And sometimes, even if you can't really afford a lawyer, it may nevertheless be worth it for you to pay for an hour of a lawyer's time to talk about something that's troubling you, especially if things haven't really hit the fan.
Agree. Thank you very much for being here on Inside Family Law. Delight to have you. Hope to have you back soon. And
anytime.
Thanks. Have a great day.
You too. Yes.
All right. Wow. Huh? What a discussion. Ari dropped some nuggets, and I was happy to have him on. Listen, if you like the content, leave a comment. If there's something else that you want me to discuss, family law related, you know what to do. Leave a comment, hit the notification bell. Every time we're about to go, either with a live stream or I drop a new video, you'll be notified. Be careful out there.